Policy Committee meeting to order. It is February 20th, 2025 at 10 a.m. I'll do the Police Policy Committee administrative announcement. Make sure I'm not getting ahead of myself here. Okay, good. This is a public meeting, subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Police Policy Committee members, unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. We'll call for introductions.
When I call on you, please state your name and who you represent for the record. We'll start with you, Chair Nowning.
Scotty Nowning, Salem Police Department, non-management law enforcement.
Vice Chair Cotting.
Casey Cotting, Oregon State Police.
Member Barrett.
Denisha Barrett, Beaverton Police, non-management law enforcement.
Member Sarek.
Anil Sarek, Washington Sheriff's Office, non-management law enforcement.
Member Daniel.
Mark Daniel, Mellington Police, Oregon Association Chiefs of Police.
Member Dressler.
Kevin Dresser, Tiger Police, non-management law enforcement.
Member Duncan.
Michelle Duncan, Lake County Sheriff and representing Oregon State Sheriff's Association.
Member Livingston.
Teresa Livingston, representing Oregon State Police.
Member Hooker.
Patty Lofgren, I am a public member and I'm from the city of Tigard.
Member Olson.
Doug Olson, FBI.
Member Rowan.
Jerry Rowan, Sheriff, Umatilla County, representing Oregon State Sheriff's Association.
Member Townsend.
Megan Townsend, representing Oregon Peace Officers Association, non-management law enforcement.
And Member Wood.
Robert Wood, represent the public.
And now for staff introductions. Juan Lopez, Executive Assistant, DPSST.
Erica Riddell, Criminal Justice Support Specialist, DPSST.
Jennifer Lavario, Professional Standards Compliance Coordinator.
Phil Castle, DPSST.
And Catherine Calhoun, DPSST.
Sam Tang, DPSST. Maury Jones, Board Member.
Kathy Pink, DPSST.
Cindy Park, DPSST.
Melissa Lane Bacho, DPSST.
Jennifer Howell, DPSST.
Back to you, Chair Nowning.
Has everyone had a chance to review our minutes from the November meeting? And if so, does anyone have any changes or recommendations? Hearing none, I'll look for a consensus to approve the minute meetings. Appears we have a consensus. Any objections? Okay. Turn it over to the Professional Standards Case Manager for administrative closures.
Thank you, Chair Nowning. Good morning, members of the committee. Jennifer Lavario for the record. The department has provided you with 9 administrative closures for on the consent agenda. The department may recommend administrative closure of discretionary professional standards cases to a policy committee when the department determines that the conduct being reviewed does not meet the statutory and administrative rule requirements for denial or revocation. Chair Nowning.
Is there any discussion about the administrative closures?
Rob Wood for the record. I do have just a concern, and maybe this is answered with procedure later. 2 of them were just incomplete investigations, which had some information concerning if they were to reapply for a law enforcement position in the future, would that come before the applicant review committee with this kind of background?
Catherine Calhoun for the record. Member Wood, no, they would not, because applicant review committee is only for those who've never served in a public agency before. So what would happen if we close this here for insufficient information that we felt we couldn't bring forward and take action, or recommend that you consider taking action? It really would then fall to the background investigation of the hiring agency to vet this out.
So that would protect the public then as well. That's the layer that, because one of them in particular, John Carter, has a high DPSST number indicating he's probably young, so he could enter the profession later.
Yes, when we close it out without consideration, again, the background investigation of the agency, the devils will be in the detail. And how much information can they get from the previous agency? In some cases, if the employee does not, maybe they resign or quit before they give any statements, in a background investigation, you would have to present that information and then hope that the investigator follows up with anything to verify the information. So that's our check and balance at this point.
Okay, thank you.
You're welcome.
Chair Downey, for the record, any other discussion on the consent agenda? Hearing none, or call for a motion to approve the consent agenda as presented.
Barrett on there.
Daniel, second.
All right, we are voting on a motion to approve the administrative closure consent agenda items. Chair Downing,
Aye.
Vice Chair Cotting,
Aye.
Committee Member Barrett,
Aye.
Committee Member Sarek,
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan, Committee Member Rowan, couldn't hear you.
Aye.
Thank you. Committee Member Townsend? Aye. And Committee Member Wood?
Aye.
Motion passed.
Okay, we'll move to the professional standards case reviews, and we are going to start with Jeremy Malone, which is in book 2. Book 2. He is here in person, so you want to stand by.
Chair Downing, may I make an announcement before we begin?
You may.
Thank you. Jennifer Labario for the record. A couple of announcements. One is the department did prepare one additional staff report for today's meeting. However, that officer asked for an emergency extension, which we granted. We may be able to bring that case to May, depends on the extent of the emergency. That case will come back to the committee. The second thing I wanted to point out was this case with Mr. Pilon. In your staff report, we have the date for the ineligibility start as the date of the conviction, which is incorrect. That should be the date of the board's review.
And then on page 4 at the bottom.
And Barrett, for the record, just above that, it shows that he is currently employed with KPE, but I'm
That
saying it
is
should be
incorrect
bigger.
as well. Those are things that got changed and not in your report. Thank you for pointing that out.
Absolutely.
Good morning.
Morning,
How do
all
you
right.
pronounce your name correctly? How do you pronounce your last name?
Elon.
Pilon, okay. Thank you, Officer Pilon. My name is Scotty Downing. I'm the chair of the Police Policy Committee. This is your time to provide a mitigating statement to the committee. You'll have 5 minutes to provide your statement, and you will be stopped at 5 minutes. There's a timer over there, and they'll give you a warning when you're close, and I will have to stop you. At the end of your 5 minutes, you won't be able to ask us questions, and we won't be able to ask you any questions.
Okay.
And then it's your choice while we discuss your case. You can either sit at the table or you can move back with the folks that you brought. It's totally up to you.
Sounds good.
Okay?
May I present the case?
Oh, yes. Correct, sorry. After she presents the case.
Thank you, Chair Downing. Jennifer Labario for the record. This is a case involving Jeremy Pilon. The department opened a professional standards review after Jeremy Pilon self-reported that he'd been arrested on November 4th of 2022 for criminal trespass 2 and assault 3 attempted in Kent, Washington. Mr. Pilon reportedly was involved in one of the several disruptions at the Showware Center Arena during a hockey game on November 4th and was asked to leave the event. Mr. Pilon was directed by a Kent police officer to leave and directed to go in a certain direction towards the exit. Mr. Pilon attempted to go in the opposite direction, prompting the Kent police officer to attempt to stop him. Mr. Pilon pushed the officer's arm out of the way in an aggressive manner, which led to his arrest. On February 21 of 2023, Mr. Pilon entered an amended plea of guilty to the charge of disorderly conduct. Mr. Pilon received a deferred sentence, a $100 fine, 18 months of bench probation, no alcohol or illicit drugs, alcohol and drug treatment evaluation, and was not allowed to go to the Showware Kent Center in Kent, Washington. The Newburgh Dundee Police Department, Mr. Pilon's current employer, conducted an internal investigation and determined Mr. Pilon violated agency policy. Mr. Pilon was given a 2-day suspension from duty without pay as an economic sanction. On August 23 of 2024, Mr. Pilon completed the conditions of his deferred sentence and the charge was dismissed. The department's review determined Mr. Pilon did violate the board's moral fitness standards as follows. Misconduct. Mr. Pilon engaged in misconduct when he was criminally charged with assault 3 and criminal trespass 2 and pleaded guilty to disorderly conduct in the state of Washington. Mr. Pilon's conduct while at the Showware event arena was unbecoming of a police officer. Throughout Mr. Pilon's interactions with the Kent Police Department, Mr. Pilon identified himself as a police officer using the phrases off-duty and you're the police, I'm police, which brought discredit or harm to the police profession and his agency and violated the board's certification standards for public safety professionals. Mr. Pilon's conduct when being asked to leave the Showware event arena by a Kent police officer threatened harm to the officer when he pushed the officer's arm out of the way when the officer attempted to stop him from walking in the opposite direction of the exit. Mr. Pilon's observed level of intoxication and aggression towards patrons, staff, and officers threatened harm to those attending and working at the event. Mr. Pilon, are you prepared to provide your statement?
Yes, ma'am.
Okay. You'll see there's a timer here, and you may begin.
Thank you. It's okay if I stand?
Absolutely.
I'm Jeremy, husband, father, son, brother, United States Marine, and from time to time I get the privilege to call myself a police officer and work in the great city of Newburgh. I have a fantastic team behind me. Hearing these events kind of rekindle that feeling. I've been sparked by a lot of failure in my life to move forward and push past hard things. Never once have I felt like a failure. I've always let my failures kind of push me forward and learn. November 2022, although that day and the days following, I was very bitter after it. I began to feel more like I'd failed, like terribly. My wife, my career, my daughter, a whole bunch of things just flooded in. I was sure I was going to get fired. I didn't know what I was going to do. I was on administrative leave. The days pushed on, turned into weeks, turned into months, and I started to pick myself up. I started to realize some of these things that I was holding on to in my life from my time in the service, never talking about them, using alcohol as a way to feel normal or at least suppress some of my feelings, really became clear to me that I was dealing with more than just some isolated incident. I wasn't much of a drinker then. I'm certainly not a drinker now. I've used this event as a catalyst in my life to never lose control of my character again. It was an extreme embarrassment to myself, to my family, to my department, to everyone who knows and trusts me. I'm considered a leader amongst my department and amongst my peers, and I've used this opportunity to kind of propel myself forward to speak the truth to other officers, to not really conceal this incident so much. I've become very much at peace with this incident. I've allowed it to really push me forward in a very positive way to, for one, to stop drinking. That has not helped me at all. I just can't do it well. And I put way too much at risk by doing it in the first place. So I found a lot of satisfaction and happiness by not drinking anymore. Got myself into counseling and stayed in counseling, both marriage counseling and through the VA, working on through some PTSD issues. I wish I would have done it 20 years ago. They teach you a lot in the Marines. You get out, they don't teach you how to talk about things that you did, things that you had to do. it's not an excuse for what I did, but it helped my actions November 2022. Just the loss and the breach of my character really got me taking a good look at who I am, what I stand for, and what I'm missing. I was pushing a lot out of my life, including my wife, my daughter, almost lost my career. I'm happy today to move forward. I knew this day was going to come. It's been looming over my head for a while. Win, lose, or draw, how you guys decide my fate today doesn't change my attitude and how I get to move forward in life. I'm very pleased with what I've accomplished in roughly the 28 months since the incident. I'm never going to repeat it. I think a big catalyst was the alcohol. But I think a bigger, deeper part of that was all the things that I was holding inside, things that I never got to talk about. Since then, I've been able to talk about them, got a lot of freedom from them. I am happy. I'm content with my career, with where we're at, with my family, my relationship with my daughter, with my wife. Yeah. Thank you guys for all being here. It's really unfortunate you guys have to be. I have nothing further to say.
Thank you. Okay, now we can open discussion about the record. If there's any questions about the record, if the record is complete, if folks think we need something else, now would be the time to discuss that. And if there are no questions about that, we're going to look for a consensus to adopt the record. If there are no questions about follow-up or anything else. Anyone? There's no questions. It looks like we have consensus to adopt the record. No objections with confirming? No objections to adopting the record?
No, and we'll note the 2 typo corrections on there, so it'll be
modified.
Exactly. Thank you.
Thank you, Captain Calpine. Now we'll open up to discuss aggravating and mitigating factors. Remember to state your name and identify if the point you're bringing up is aggravating or mitigating.
Mark Daniel for the record, mitigating. Officer Pinion is here today and accepts responsibility for what he's done. I also found that mitigating the letter from his chief, from the captain that actually conducted the investigation, the fact that he self-reported and that he accepted his discipline, went to counseling and actually changed his alcohol consumption behavior. That was all he mitigated.
Kevin Dresser for the record, kind of piggybacking that for mitigating circumstances, just with regard to statements made by the investigator with Newburgh Dundee Police, how out of character this episode was for the officer. And one other thing also that I noted was it seemed that there was a point where there was an allegation where one of the Kent police officers might have aggravated the situation and wasn't exactly caught on body cam, but it seemed that part of the investigation seemed to sustain that there was potentially a derogatory comment by one of the Kent officers that just wasn't, the audio wasn't caught because of the buffer of one of the body cam. But the investigators at Newburgh Dundee seemed to think that that might have been an accurate statement where that Kent officer kind of poked the bear at some point. So, but again, with everything in the report, his agency representing him today being here and his comments today, I think this was an isolated incident, extremely out of character. At least that's how it reads to me.
Thank you.
Member Townsend, mitigating, just wanted to add prior cases for officers that may have been in similar circumstances that were arrested and put on probation or misdemeanor situations that completed their, I guess, probation or whatever they were sentenced to, that were able to admit responsibility and change their life and came back to service. And it's noted at the end of the record here with these, I think there were 2 officers that was included in this record. Similar, not similar fact pattern, but similar type of situation.
Scotty, now for the record, I think aggravating, I think some of the fact patterns on those are similar. However, I think the way that he treated the police, I think, is aggravating. And to your point, Kevin Dresser, I think that there was a point where they think they got fed up. But it was a long time into it. I think he had ample opportunities to walk away. And I think those officers actually were very calm for a very long time in trying to deal with him, especially when he continued to identify himself as a police officer vocally. So they, you know, as the public's watching them as well, they're watching the other officers saying, how are you going to react to this person who's a police officer? So I think it's aggravating that you put those officers in that situation. I agree also the mitigating parts, it seemed to be an extremely heartfelt mitigation. And you know, really touched all the points that I had for concern. And so I do appreciate that. Anyone else? Aggravating, mitigating factors? Hearing none, I'll turn it over to you to review. Thank you.
Thank you, Chair. Jennifer Lavario for the record. For mitigating, I have Mr. Pilon is here today. He accepts responsibility. His verbal mitigation was heartfelt. The letter from the chief and the captain who did the investigation were mitigating. The fact that he self-reported the incident, he accepted the discipline, he put himself into counseling and treatment. Additionally, the statements by the investigator about his behavior being out of character, the allegation of there being an aggravating derogatory comment by the Kent Police Department, which did not occur on tape or audio, may have been a poke the bear type moment. The agency being here today is mitigating. Again, it being an isolated incident is mitigating. For aggravating, I have the way that Mr. Pilon treated the police was aggravating. They may have been fed up, but they had been with him for quite a long time and remained calm for quite a long time.
Looking for a consensus that Jennifer caught all of our aggravating and mitigating. Any thoughts on that? Anything missed? So we have consensus. Okay, now we'll open the discussion of whether there was a moral fitness violation. We can either affirm, accept as it is written, modify it, or negate, which is remove all. And so I would, as we see, we're looking for a motion to either affirm, negate, or modify the violation.
Rob Wood for the record, I move that we affirm the staff's findings.
Cotting, second.
All right, we are voting on a motion to affirm the moral fitness violations. Chair Downey?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
So now we need to make a motion to either take action or take no action. If we take action, it would begin at the board, at the date of the board, which is a correction from our, and then our options for action are
3 to 10 years.
3 years to 10 years if we take action. So looking for a discussion, motion.
Rob Wood for the record, as committee member Townsend pointed out, to be consistent, his lawyer provided us previous cases that have come before the Police Policy Committee And Officer Pilon has taken full responsibility, never denied any of this, and completed all of his probationary requirements. So I'm going to make a motion, maybe, or we can discuss further that we take no action.
Livingston, I second the motion to take no action.
There we go.
All right, we are voting on a motion to take no action. Chair Downing?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend? Aye. And Committee Member Wood.
Aye.
Motion passed.
Thank you.
Thank you.
Thank you, everybody.
We will then move to same book, just before Elon, and that's Jared Paul.
Jared Paul.
Jared Paul.
Thank you. That is a compliment.
Book two, yeah, just one.
Jared's Hall.
Jennifer, you don't want to discuss this case?
We couldn't have that latitude.
Jennifer, you might want to actually present this case as well. You know, I'm trying to save some time.
Scotty might just start doing these all by himself.
Calling on myself, seconding.
Because I used to think it was 5, 7, 10, no, it's in the but the discussion is.
I can tell by the look on your face, you're like, he's gonna go right by me.
Especially like in the case that may have been late in the computers. Yeah, you could.
Years ago.
Yeah, you did.
Make a note that we need to.
Basically, in front of you.
You think I don't need a script? I need a script. Yes. I'm always planning to look at the script. Thanks for the color coding and everything.
Okay.
Yes.
Good morning. My name is Scotty Downer, I'm the chair of the Police Policy Committee. This is the time for you to provide mitigation to the Police Policy Committee. You'll be given 5 minutes exactly to provide a mitigating statement. At the end of the 5 minutes, I will stop you, I'll cut you off. And we won't be able to ask any questions of you, and you won't be able to ask any questions of us. When we're done, you can sit at the table here if you'd like, or you can sit back with the folks you brought. It's totally up to you. And then when we're done with the case, you can exit out the side door. Jennifer Lavario will present your case, and then you'll be given an opportunity. And there's a timer also, you'll see the 5 minutes. Any questions?
No, sir.
Okay. Jennifer?
Thank you. Jennifer Lavario for the record. This case involves Jared Paul. The department opened a professional standard review after receiving a notification from the Law Enforcement Data System, or LEDS, that Jared Paul had been arrested on July 22 of 2022 in Lincoln County, Oregon for assault in the 4th degree, menacing, and assault in the 2nd degree. Mr. Paul reportedly assaulted an individual who he observed making out with his wife, and in doing so, the individual sustained a fractured leg. On January 23 of 2024, Mr. Paul was convicted of assault in the 4th degree and acquitted of menacing and assault in the 2nd degree. Mr. Paul was sentenced to 36 months of bench probation, anger management evaluation, no contact with the victim, and restitution in the amount of just over $30,000. On March 6th of 2024, Mr. Paul resigned from the Oregon State Police while under investigation for allegations that during the investigation and trial for the criminal charges, he was untruthful both with the criminal investigators and while testifying in court. Additionally, the conviction of assault in the 4th degree precluded Mr. Paul from possessing, owning, or controlling a firearm for 36 months, 36 months, which was an essential duty as a police officer. The department's review determined Mr. Paul violated the board's moral fitness standards as follows. Although the Oregon State Police found Paul was dishonest, the department did not find sufficient evidence to court. Wow, let me start that one over. Although the Oregon State Police found Paul was dishonest, the department did not find sufficient evidence to support a finding of intentional dishonesty. Our moral fitness definition includes intentional. We did find misconduct. Mr. Paul violated criminal law and was convicted of assault in 4th degree and misdemeanor. Mr. Paul harmed a person when he physically pushed them, causing them to fall and sustain broken bones. Mr. Paul's conduct caused his wife to feel a threat of harm to herself due to his assaultive reaction to the situation involving her and because of his police officer status. Mr. Paul's conduct violated the Criminal Justice Code of Ethics and harmed the reputation of the Oregon State Police and the police profession. Are you prepared to provide your statement?
Yes, ma'am.
All right, you may begin.
Good morning, members of the committee. I stand before you today with humility and deep regret to ask for your consideration regarding the review of my police certification. I take full responsibility for my actions, and I recognize the seriousness of the situation that brought us here today. The incident in question happened during one of the most painful and emotionally charged moments of my life. I discovered my ex-wife's infidelity, and in that vulnerable state, I made a terrible decision that I'll always regret. The decision was completely out of character and not a reflection of who I am as a person or as a law enforcement professional. From the beginning, I have cooperated fully with the legal process, accepted the court's ruling, and have taken every opportunity to reflect on how I can grow from this experience. I've completed a 12-week anger management course through the court's process, and also have been doing therapy and counseling on my own. I've learned difficult but valuable lessons about accountability, emotional resilience, and the importance of maintaining the high standards that come with the privilege of serving in law enforcement. I want to emphasize that this incident is a one-time occurrence and not a pattern of behavior. Throughout my career in law enforcement and my time in the military, I've served with integrity, dedication, and a deep commitment to my community and country. I've always taken pride in upholding the values and standards expected of me. I also want to address concerns of discrepancies in my statements. Any inconsistencies during the 911 call that night were unintentional and the result of a chaotic and highly emotional situation. My sole focus was ensuring medical help arrived as quickly as possible. I deeply regret any confusion caused by my words, but I want to be absolutely clear. I never intended to mislead anyone. I fully understand how rare, if not unheard of, it is for someone in my situation to return to a career in law enforcement. However, I believe it is still possible. If my certification is kept intact, it would give me a fighting chance at that possibility. I know that any agency considering me would certainly dig deep into my background and want to know and understand who I am and what I've learned and the type of person I've become. I believe that given the opportunity, an agency would not just see my past, but also recognize the strengths that I bring, the lessons I've learned and the resilience I've gained, and the skills and experience I've built over my years of service. I truly believe I could be an asset to an agency in one capacity or another. This experience has given me a unique perspective that could help me connect with others and be more empathetic. Be a more empathetic, thoughtful professional. With my training, military experience, and law enforcement background, I know I have something valuable to offer if I'm given the chance to rebuild. I am fully aware that trust and moral fitness are essential in this profession. This experience has been both humbling and life-altering. Despite my mistakes, I believe that the single moment does not define who I am or what I can still contribute to the field of law enforcement. It has always been my calling to serve others. I hope to return to this profession when the time is right, not to erase my past, but to build on it and be a better officer and a better person moving forward. Retaining my certification would give me the opportunity to do just that, to continue to learn from my mistakes and regain the trust and duty that I once held. Thank you for your time and considering my request. I hope you'll find that despite my shortcomings, I'm someone who is willing and able to grow from this experience and continue to serve my community with honor and integrity. Thank you.
Thank you. Scotty Downing for the record. Now we'll begin discussion about the record. Is it complete? Is there questions about the record? Is there additional things we would like to see? And Scotty Downing for the record, I have a question. The 911 call.
Are you wondering if do we have it?
Do we have it?
No, sir, we do not.
Okay. Did we try to get it?
I did not.
Okay. Does anyone else have concerns about the 911 call, or would you want to hear the 911 call? Just me.
I guess Kevin Dresser for the record, it would have been nice to have it, but I do look that his agency at the end didn't include that in reference to the intentional dishonesty part. Does that make sense?
Yeah, I'm just having a little bit of a congruency issue with the dishonesty. I think our record doesn't necessarily show that, the dishonesty part, so I feel there's parts missing.
For the record, I wrote that down, and then also there was a mention of dishonesty during the trial or during the investigation component, and I didn't see that in there either. So I don't know where the dishonesty parts came up, because nothing that I read highlighted any of the dishonesty components.
Catherine McAlpine for the record, just want to clarify, since we are not presenting this dishonesty because we did not feel that we could identify intentional, even though there was allegations. Just want to be clear that are you weighing that you would like to add dishonesty to it, or just what are your thought processes around dishonesty? We can help.
And Scotty, for the record, there's just throughout reading the entire case packet, there's all these references to dishonesty, but then there's just not substance to back it up. So that's at some point in this investigation, someone thought he was dishonest, and whether or not they came to that conclusion is also a little bit unclear. So I was just always looking for more information so we can make a good decision.
Matt Berlin, it's nice. I know I work for the Oregon State Police, so I'm just speaking into the record that is sitting in front of us. And from what I understand, he resigned prior to the conclusion of the allegations of those. So I think that there was just the information wouldn't be complete in the sense that the investigation, he resigned prior to the conclusion of the internal investigation regarding those allegations is what I was reading through, and why you guys decided not to add that was because there was no completion of that.
Barrett, for the record, I know that this is kind of, I think maybe Ruby's going with this, it's nice to have the full picture, right? If we hear about a 911 tape, it's nice to have that in there because it gives us more context. I can read in here that he was actually the one that called 911. That changes things in my mind versus a bystander calling, or him staying and hanging out, or him leaving. All of that stuff just kind of helps to paint a big picture of the entire scene versus only giving us the parts that fit what we want to discuss or not discuss. And we can always, and we've done it in the past, we've taken things out of the record, we've put things in the record based on the whole picture. I guess that's why. It stuck out to me that it didn't seem complete.
Dresser for the record, it's even, from the trial standpoint, I mean, 911 call, we get there was a 911 call from the trial side. We have no, there is no, any reference to what that is referring to.
Correct. Scotty, down to the, I mean, I think that it works both ways. There could be information in there that is aggravating, and there could also be mitigating information. And from his own mitigation statement, he mentioned the 911 call and his intention. I would like to hear it. So I think the committee could then decide, is this worthwhile? Does this help the case? Does it hurt the case? So I would make a recommendation, and I hate to do this, but to send it back for more, to try to get more information about the references that are made at the trial, if that's available to us, and certainly the 911 call.
And Barrett, for the record specifically, is there a Brady ruling? I know that stuff can come out of the trial part if there's dishonesty.
Jennifer Lavario, for the record, I do have questions about that out, and I have not received an answer yet about that question.
Scott, now, did we try to get the 911 call, or were we not able to get it, or is it just something we just didn't do because it wasn't a part of the dishonesty, was a part of the allegation from OSB?
What I can say is that when we reach out for the records on a separation, we ask for all audio, video, the whole investigation. What we receive for an investigation that might not be complete will be sometimes not complete. We may not have that information. And when we assessed the dishonesty piece, we considered, like Kathy was talking about, does this look like it's moving in an intentional direction for us based on the OAR? And so we didn't move any further with that piece. If the committee wishes to move in that direction, we certainly can get that information.
Captain McAlpine, for the record, especially if we're talking about a 911 tape, there's a likelihood that that should be available to us. And again, those are things that we can attempt, versus if somebody elects not to participate in an interview, we'll never be able to capture that and maybe only hear one side of it during mitigation. But definitely we can attempt to get that 911 tape. And then look to see whatever court records are available in this category and bring it all back to you.
Does that need a motion or a consensus, or what does it need? Consensus? Just send it back, or we
I would
just don't?
I prefer a motion to send it back for further and to vote on it, please.
Okay. Scotty, down for the record, I'd make the motion that this case be returned for additional information that we discussed.
And Barrett, I would second.
All right, we are voting on a motion to return the case to staff for further information. Chair Nowning?
Aye.
Vice Chair Cotting?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sarek?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lothman?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Nay.
Motion passed.
Thank you.
Jeremy Oswald. If we see him virtually.
Did not see a name listed, or a third name listed for someone that would have talked this in right lane.
Why can you just ask him? He's online.
In the chat.
And if it doesn't, that's
Terry Rowan, I just had a question. I didn't catch the name of the next person.
We are checking to see if Jeremy Oswald is remote. That'll be our next case. He is.
Okay. Thank you.
Do you want to move to, do you want to swap those two to give them an opportunity? Maybe we're moving quicker than.
Do you have anything further? Do you have any emails that say he's having trouble with the link or anything?
I didn't have any
Okay.
now since the last time. I just looked a few minutes.
And they're instructed to check on it at 10, is that correct?
Yes.
Okay.
I just spoke to him yesterday.
Okay. It's 10:45, I think that's plenty of time.
Captain Hogan, for the record, Chair, just on abundance of caution that perhaps there is a disconnect, could we move on to the rest of it and then we'll check later?
Absolutely.
I'll give him a little bit more time.
So we'll go to Bradley McIntyre.
That'd be great.
And he is not here, is that correct?
Correct.
Okay.
So that'll be book one.
Whenever you're ready, Jennifer, thank you.
Thank you. Jennifer Lavario for the record. This case involves Bradley McIntyre. The Department opened a professional standards review after receiving information from the Portland Police Association on March 2, 2021 that Bradley McIntyre was criminally cited for driving under the influence of alcohol, or DUII, on February 26 of 2021 in Portland. On January 31 of 2023, Mr. McIntyre retired from the Portland Police Bureau, or PPB, while under investigation for allegations of misconduct related to the DUII. The PPB found that Mr. McIntyre operated a PPB vehicle while on duty and under the influence of alcohol. During the PPB investigation, they also discovered that Mr. McIntyre had been arrested for a second DUI in Placenta, Washington on February 3rd of 2021. During this incident, Mr. McIntyre attempted to leave the scene after he was involved in an accident. The PPB also determined Mr. McIntyre was untruthful when he did not report the second off-duty accident and DUII. The department's review determined Mr. McIntyre violated the board's moral fitness standards as follows. Mr. McIntyre was intentionally dishonest when he omitted to report to the PPB that he had been in an off-duty vehicle crash resulting in a DUII charge. Mr. McIntyre was intentionally deceptive when he attempted to leave the scene of the crash on foot. Mr. McIntyre drove, this is misconduct, pardon me. Mr. McIntyre drove a PPB vehicle and performed his PPB duties while on and off duty and under the influence of alcohol, which threatened harm to persons and property in Oregon and Washington State. Mr. McIntyre engaged in misconduct when he entered a plea of guilty to DUII on June 1 of 2021, a violation of Oregon criminal law. Mr. McIntyre engaged in misconduct when he was sentenced by a Clark County judge to deferred prosecution for 5 years after pleading not guilty to DUII on February 17th of 2023, a violation of criminal law in the state of Washington. Mr. McIntyre harmed the efficient operations of the Portland Police Bureau by driving an agency vehicle while under the influence of alcohol and on duty, performing his PPB duties in Oregon. Mr. McIntyre harmed property and himself, as well as threatened harm to others when he drove his vehicle under the influence of alcohol in the state of Washington. Chair Nownie.
Thank you. Looking for discussion or consensus to adopt the record, modify the record? Any discussion about shortages of the record? Seeing none, I'm getting thumbs up to consensus to adopt the record as presented. No objections? No objections? Okay. So we'll open up the case for discussion of aggravating and mitigating. Reminder, state your name and identify what you're stating as aggravating or mitigating. Chair Nowning, I'll start. Aggravating. Obviously, he was on duty. At the second one, he was on duty and well into his shift, and he still blew a .26 while out performing law enforcement functions. He said he drank at 3 o'clock. I think his BAC was at 1:30 in the morning. The math isn't math, and he was likely drinking on duty, which I think is extremely aggravating. And also when he got called out and told to sit in the car, he took off. But I could probably go on and on. There's a lot of aggravating parts of this case.
Kevin Dresser for the record. Obviously aggravating is disregard for public safety by operating a motor vehicle to the crime scene. But the other thing I think of as an investigator myself is jeopardizing a homicide investigation. It's fortunate that the sergeant on duty, his behavior was such that it caught their attention and they pulled him off that crime scene. But that could have definitely affected that in the long run also. So that was a huge factor with aggravated facts as I read the case.
Michelle
Townsend?
Duncan. Oh, sorry. Go ahead. Go ahead. Michelle Duncan, for the record, aggravating failure to report the first DUI, that there were 2 DUIs in a short period of time, and as well as trying to leave the scene of the first DUI. Again, we'd probably go on the aggravating.
Weird, I was gonna say the same thing.
Sorry.
Anyone else? Aggravating, mitigating?
I think Kevin Dresser, for the record, another aggravating point. It seems after the fact, and he's in the process of dealing with this in the aftermath. Supposedly he's seeking therapy and different things, but then there's social media of him in Mexico vacationing. Obviously, none of us can be sure it was described as him in pictures drinking. Obviously, we don't know what were in the glasses. It could have been anything, but that also struck me that during this process, he's posting that kind of thing and has that sort of appearance given the gravity of both these incidents.
Scott Downing, for the record, aggravating also the BAC in both. We think the first one was a 0.19 and the second one was a 0.26, extremely high BACs. So this isn't like he had a couple of drinks, it was close. This is extremely intoxicated.
Barrett, there was a little bit of evasive behavior. Barrett, for the record, there's a little bit of evasive behaviors regarding his IA interview. It had to be rescheduled due to looks to be rightful reasons. But then when they got the all clear and rescheduled it, he didn't show for it. I think that shows a little bit of evasive and not want to take responsibility, maybe.
Anyone else before Jennifer recaps? Go ahead.
Thank you. Jennifer Lavario, for the record. I have no mitigating circumstances, but I do have aggravating. On duty, this behavior happened while he was on duty and well into the shift. At that point, he still blew a .26. He said he drank at 3 o'clock, but it's likely he drank on duty. He took off when he was told to sit in the car. There was a disregard for public safety. He jeopardized a homicide investigation. He failed to report his first DUI. His second DUI, he had 2 DUIs in a short period of time. His trying to leave the scene in the first DUI was aggravating. The social media post of him in Mexico while in this treatment program, given the gravity of the situation, was unbecoming of a police officer. He had BACs of 0.19 and 0.26 were both very high, suggesting he potentially drank quite a bit. His evasive behavior due to his IA interview being rescheduled, and then when it was rescheduled, not showing, in essence, that perhaps showed that he didn't want to take responsibility for his actions.
Chair Downing, for the record, we're looking for a consensus that Jennifer Lavario has captured the aggravating issues that we have a consensus. We'll open up the discussion about the moral fitness violations, either affirm, modify, or negate, and we're looking at dishonesty and misconduct both. So we can open up the discussion about that.
Mark Daniel, for the record, I just make a motion that we affirm the record.
Scotty Downing, for the record, I'll second.
All right, voting on a motion to affirm the moral fitness violations, Chair Downing,
Aye.
Vice Chair Cotty,
Aye.
Committee Member Barrett,
Aye.
Committee Member Sarek,
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend, and Committee Member Wood.
Aye.
Motion passed.
Now we're looking for a motion to take action or take no action.
Michelle Duncan, for the record, take action.
Good.
Rob, I
I
second.
second that.
All right, we're voting on a motion to take action, Chair Downing,
Aye.
Vice Chair Cotty,
Aye.
Committee Member Barrett,
Aye.
Committee Member Sarek,
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
Thank you. We're looking for a discussion and a motion for the amount of time for ineligibility. And we have dishonesty and misconduct, which the misconduct in this will be 3 to 10 years, and the dishonesty could be maximum of lifetime. Correct.
Kevin Dresser, for the record, I would make a motion for a lifetime.
Mark Daniel, for the record, a second.
We have some discussion about your thoughts and why that is.
Michelle Duncan, for the record, some clarification. Do we have to make like 2 separate decisions on each of those, or just one is fine?
One is fine.
Okay.
Kevin Dresser for discussion. Just the gravity of the situation with the BACs, everything that we've already discussed, the jeopardy he put himself and the public in, the effect on the position of investigating a homicide, and then just the evasive behavior after the fact, and not necessarily coming to terms or taking responsibility, at least effectively we get through the investigation. And that's why I made a motion that I did for lifetime.
Thank you.
Mark Daniel, for the record, I agree with Member Dresser all the way. I think that this situation as presented is extremely aggravating. He had an opportunity, most certainly, when he was arrested in the Clark County area, to perhaps even bring that forward and to seek assistance, to seek help, to conceal that, and then yet come to work intoxicated, drive a police vehicle intoxicated, and respond to a homicide investigation intoxicated is just beyond anything that I can comprehend. So I believe that a lifetime suspension is appropriate in this matter.
Thank you.
All right, voting on a motion for a lifetime ineligibility period, Chair Downing,
Aye.
Vice Chair Cotty,
Aye.
Committee Member Barrett,
Aye.
Committee Member Sarek,
Aye.
Committee Member Daniel,
Aye.
Committee Member Dresser,
Aye.
Committee Member Duncan,
Aye.
Committee Member Livingston,
Aye.
Committee Member Lofgren,
Aye.
Committee Member Rowan,
Aye.
Committee Member Townsend,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
That was perfect, thank you.
So I knew it was, that's what you were saying. You want to set?
And Chair Captain Kaplan, for the record, I think we're ready to proceed with our last case in Oswald.
Did he show up?
I have no indication from him that he's having any difficulty signing on or anything.
Okay.
For the record, we've been communicating, I think, several times, he's fully aware. It is not surprising that maybe he elected not to come in, so I think we feel pretty confident that we can proceed.
Can you just shout out for him one more time to see if he maybe?
Sure.
Jeremiah Oswald, are you on the line?
He wouldn't show up right here, so.
And his attorney's not here either, correct?
Correct.
Okay. Okay, proceed, thank you.
Thank you. Jennifer Labario for the record. This is the case involving Jeremiah Oswald. The department opened a professional standards review after receiving an F4S personnel action separation form from the Washington County Sheriff's Office stating that Jeremiah Oswald resigned on September 7, 2022 in lieu of termination. The Washington County Sheriff's Office conducted an internal investigation after receiving a complaint of how Mr. Oswald handled the return of a suspect's cash. Mr. Oswald had allegedly lost a portion of the suspect's confiscated cash and then withdrew cash from his own bank account to cover the loss. Mr. Oswald stalled the booking process when he was made aware by them that cash was missing from the suspect's belongings. Mr. Oswald did not admit to what he had done until provided proof of his actions by the Washington County Sheriff's Office investigators. The Washington County Sheriff's Office found that Mr. Oswald violated several policies, including truthfulness, and determined termination was warranted. The department's review determined Mr. Oswald violated the board's moral fitness standard as follows. Dishonesty. Mr. Oswald admitted he was intentionally dishonest with the Washington County Sheriff's Office investigators about his actions related to losing a suspect's confiscated cash by attempting to mislead the investigation and cover up his actions. Misconduct. Mr. Oswald's conduct regarding the suspect's missing cash harmed the efficient operations of the Washington County Sheriff's Office by delaying the booking process, undermining the internal investigation, and tarnishing the integrity of the agency.
Thank you. Well, looking for a consensus on the record to adopt it. Does anyone need anything else? Seeing consensus, thumbs up to adopt the record as presented.
Robert, for just discussion purposes, and help me on the misuse of authority. Isn't having the authority for care and custody of evidence and potentially losing that a misuse of authority?
Just got it down for the record. I mean, I guess it could be. Right? I would say that's more that's a more nuanced allegation. I think there's some more direct allegations that probably cover it. I mean, that's my opinion for what that matters.
And maybe it doesn't matter with the other two moral fitness violations we have.
I do appreciate the record. I'm sorry. I appreciate that.
The record, just so everybody has it handy. Misuse of authority is intentional conduct that includes the use or attempted use of one's position or authority as a public safety professional to obtain a benefit, avoid a detriment, or harm another.
So I guess we'd have to say, was it really lost? And we don't have that for sure with us. Or was it taken? So again, I'm still thinking though, with the dishonesty, I think we've got ourselves covered as far as periods of revocation if we go that way.
Michelle Duncan for the record. The way I read it and just thinking about it, because it crossed my mind what you're saying, but on the other hand, if he had taken the money, he would have given that money back, not gone and got other money out of the ATM to cover it. So that kind of shows me that he probably did lose it, and it's not necessarily something where he was using his authority to get cash.
I do appreciate the conversation. I do, Scott, after, I do think that's a more nuanced allegation. I think the other two are more direct and easier to wrap, at least for me, to wrap my mind around. And then, like we said, I think they cover any period of ineligibility that would cover, so. But I do appreciate the conversation. Do we have a consensus to adopt the record? Appears we do, thank you. It's time now to talk about aggravating and mitigating factors. Make sure that you state your name and identify if what you're talking about is aggravating or mitigating.
Rob Wood for the record. I know we're not supposed to read between the lines and interpret anything that's not actually here, but I have a theme as I'm reading through this of having no recollection of something until it's brought to them during evidence, and then all of a sudden, oh yes, I guess that's right. A bunch of instances occurred during the entire investigation, where he was when he was searching the vehicle, what he was purchasing at the store, did he even go to the store, did he even get cash back until they were able to show all this kind of stuff. All those things, I think, in my opinion, are very aggravating to the fact of, was it lost or not? I don't know. Because if it was truly lost, why would he go replace it? That was a concern I had also. Lost is lost. There's all sorts of possibilities that aren't addressed in here, but it brings up all sorts of concerns. That theme I'm talking about that I am not trying to read between the lines, but the feeling I get when I'm reading the entire record.
Scott, down for the record, even the investigator did point that out, and it is in our record, where the investigator pointed out that he would not admit anything until he was confronted with evidence, and they pointed out multiple different incidents of that. So I don't think you're reading between the lines. I think that was identified by the investigation as one of their concerns as well. They would ask him, he would say he didn't know, and then they would show him what they had, and then he would remember, which is very it's a common thing in law enforcement.
Yeah, Robert, I think I need to clarify my comment. It's the reading between the lines of what actually happened to the $50 bill, not the 150, because there was a bunch of hundreds, but there was only 150, which implies that, oh my gosh, the intake didn't account for a $50 bill when they were logging the evidence. That's why I went back to that misuse of authority, but again, I don't think the record supports that verbatim. It's just, like I said, that feeling I get.
Catherine Calpine for the record. Member Woods, I appreciate your comments, but can I nail down exactly on the record the aggravating and mitigating that you want to, not the implied, but the ones based on the facts that we have here, what you would like to point out?
Yeah, aggravating would be the dishonesty with the investigation and not having any recollection of anything until it's pointed out.
Thank you. Appreciate it.
Yep.
Kevin Gressel for the record.
Terry Rowan for the record.
Member Rowan, you can continue.
Oh, okay, thank you. I guess mitigating would be the fact that he went and got his own money and to make the individual whole again, but aggravating is the delay in which the timeline that this all took place in. And also aggravating is just this continuous path of false statements that he made. And like what has been said, until he's like caught in it, then he finally comes clean with the information.
Thank you. Other aggravating, mitigating?
Barrett for the record. It's aggravating in that there was such a simple correction in this, and you don't know the patterns of behavior for this individual leading up to it. You don't know if this was their second or their third time losing stuff. I've lost cell phones. I've had prisoner property on top of my car and driven off and I've lost it. So it's aggravating that there was such a simple solution to this, and he went down a true rabbit hole to try to cover it up. Yes, he did make the person whole again by giving the money back. But once he started, he just couldn't stop, and I found that uncomfortably aggravating. I almost feel sorry for him to some extent.
Scotty.
Kevin Dresser, for the record, that's what I was going to say too. There was plenty of time to redirect, plenty of sleep cycles, all kinds of things between these interviews for him to do this, but he kind of maintained it until he was truly confronted with the evidence against him and finally came forward with the truth then, but not before then.
Scotty Down, for the record, aggravating is, the jail staff and even the jail deputy was saying how stressed out she was because this person is due to be released and she can't, we're restricting someone's freedom who would otherwise be released because this person misplaced or lost $150 and won't come forward, and it's putting other people in a really tough position. And he seemed very laissez-faire about it. He didn't hustle back to the jail. It took him a long time to get there. Meanwhile, this person is there hours after they should be released. And I think that's a very aggravating factor here that he was over $150 he's going to do this. Anyone else? All right, Jennifer, if you want to recap, thank you.
Jennifer Labario, for the record. For mitigating, I have that he did go and get money out of his own bank to make the person whole. For aggravating, I have there were recollection problems all throughout the investigation until he was confronted with evidence, which is a theme throughout many of your aggravating statements. However, I'll just go through them. Just his basic dishonesty with the investigation, his delay in the timeline of the investigation, his path of false statements until he's caught. This could have been a simple correction, although it could have been a simple correction. He had plenty of time to own up to this, but he went down this rabbit hole of covering instead. He was rather nonchalant about the stress he was putting on jail staff and how this was being delayed. And jail staff were stressed because they were trying to get someone released and they couldn't do so.
Barrett, for the record, can I add that there's no mitigation, there's no written or verbal. He didn't show up either, which it shows a continued pattern of not wanting to discuss this, talk about it, fill in the blank.
We're looking for a consensus that Jennifer was able to capture our aggravating and mitigating. Any comments? Anyone have anything to say contrary to that? Looks like we had a consensus. Thank you. We will move on to whether or not there was a moral fitness violation. We need to affirm, modify, or negate the findings. And this was dishonesty and misconduct.
Townsend, I'll make a motion to affirm.
Barrett will second.
Any discussion about that? Discussion?
All right, we are voting on a motion to affirm the moral fitness violation. Chair Notman?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sterrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren? Aye. Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Now we need to discuss whether we want to take action or not.
Barrett, I move that we take action.
Dresser, a second.
Those are too fast. All right, we are voting on a motion to take action. Chair Nownie?
Aye.
Vice Chair Connie?
Aye.
Committee Member Barrett?
Aye.
Committee Member Sterrett?
Aye.
Committee Member Daniel?
Aye.
Committee Member Dresser?
Aye.
Committee Member Duncan?
Aye.
Committee Member Livingston?
Aye.
Committee Member Lofgren?
Aye.
Committee Member Rowan?
Aye.
Committee Member Townsend?
Aye.
And Committee Member Wood?
Aye.
Motion passed.
Okay, now we need to have a discussion about the ineligibility period. This includes a dishonesty, which is up to a lifetime ban. So we're from 3 years to lifetime. And if you do make a recommendation of a time, I would appreciate if you just, a little bit of what, for the record.
Cotting will make a motion for lifetime, just with the repeated failure to own, force the investigators to pull it out of them, lack of mitigation throughout, including today. I think a line was crossed, I think it's clear it was dishonesty in several categories, in my opinion. So I think it's appropriate for a lifetime suspension.
Probably for the record, I'd second that. I'd also point out, not only were these little bunch of lies, they were made up stories about how he found the money in the oil well and all this stuff. So I would second a lifetime.
All right, we are voting on a motion for lifetime ineligibility period. Chair Nami?
Aye.
Vice Chair Connie?
Aye.
Meeting Member Barrett?
Aye.
Meeting Member Sarah?
Aye.
Meeting Member Daniel?
Aye.
Meeting Member Dresser?
Aye.
Meeting Member Duncan?
Aye.
Meeting Member Livingston?
Aye.
Meeting Member Lofgren?
Aye.
Meeting Member Rowan?
Aye.
Meeting Member Townsend? Aye. And Committee Member Wood?
Aye.
Motion passed.
That concludes our case reviews. Captain McAlpine wanted to address the board
Thank you.
before AGCF.
Absolutely, thank you, Chair. Captain McAlpine for the record. On occasion, within our rules and bylaws, we can add an additional committee when needed. So on top of the 4 that are scheduled, to perhaps add another one. I'm doing a pulse check to see if there is the ability, appetite to possibly have one in April for the May one, before you get your packet, to review probably at least one case and some closed ones. But the one case is more time sensitive, and would like to get it before the committee, which will also then get the board the ability to look at it instead of waiting another 3 to 4 months. So I wouldn't overwhelm you, but I would like to also parse it out from the May list, which I think is fairly extensive, and see if I can at least get enough for a quorum to maybe have a meeting in April, which would mean you get your material in March for you to review that case and possibly a couple of admin closures. So I can reach out further by email if you want, but just want to put it on your radar. You don't have to commit now, but just want to give you a heads up and a little bit of pause. I'm aware, I believe in April we have maybe an OACP conference and an OSSA conference, so I'll look to not interrupt those, but reach out and just see if we're able to have our ducks in a row and be able to convene an extended committee meeting. Jennifer, anything else I need to advise on? That's it, okay. So again, just a heads up, and look for some email communications shortly following this meeting. Thank you, Chair.
Thank you. Director Castle.
Thank you, Mr. Chair. Members of the committee, Phil Castle for the record. Appreciate the opportunity to be here and speak with you today. First thing I like to start off and say, and I really mean this, as we've just asked for you to serve even more time in the next quarter, is I want to thank you very much for being here. I know this is a huge commitment for you all. There's so much homework that has to be done before you're coming here, but this is also so critically important for our state. So I'm just grateful for your willingness to be able to do this. It's a big deal, so thank you very much. I also really want to thank the staff for all the work that goes into this. Thank you so much for this, and it is a tremendous amount of work for them to do that. And they're a little mad at me right now. I have to tell you, the staff is a little mad because I have taken the professional standards director and asked her to move into the deputy director position, and she has agreed to do that yet again to work with me. So I'm super grateful for that, and congratulate her. And also congratulate Bill Steele for his retirement. He's retired He did an amazing job for this agency and the roles he served, and he stepped into the role that I needed him to step into rapidly and very well. And really grateful for him. And he won't like watching this and being embarrassed by being named, but great person, great human being, and great professional. So really appreciate him. You know, like every other state agency, we are in the throes of legislative session right now, and literally as we speak, we have 2 bills on the House floor with recommended approvals from subcommittees. Our legislative concepts that have gone through. The first one of those was House Bill 2916, which was a administrative correction to how we appoint members on the Fire Policy Committee. We also have House Bill 2926, which is really relevant for this committee, and that is DPSST's authority over not yet certified public safety professionals. Most of you well know that DPSST does not have authority over public safety professionals when they are not employed and have not yet been certified. So an example with that would be a recruit within the academy who is dismissed for some reason, and the owning agency decides to terminate that recruit. We then lose authority to adjudicate that potential moral fitness violation. This bill corrects that, gives us the opportunity to adjudicate that and bring that in front of this committee or whatever committee it so applies to, and to be adjudicated. So that one we're very happy about. We have about 158 of those folks right now who are sitting there in what we sort of have nicknamed purgatory. And those folks will get the opportunity, if they so desire, to have their case, or we may choose to have their case heard in front of you. So the process remains the same, nothing changes, just gives us the opportunity to resolve it. So we're happy about that. Wait time right now to get into DPSST basic police course is sub 30 days. And that sounds like a really good news story, and in part it is, but for the most part, it's too soon. It means that we are underfilling classes and we're wasting resources, and that is, it's not good for us. So much to a point that we've had to cancel a class in March in order to build a little bit of a backlog so that we can fill our classes. This is a temporary issue. The vacancies that we had last year and last biennium are all still there. The problem, as you all well know, is the availability of qualified candidates, good hiring pools, passing background checks, those kinds of things are problematic, as well as the amount of laterals that are moving through the state right now, which is about 30%. 38% of all hires are laterals. Only 12% of those are coming from out of state. The good news of that is 12% of those are coming from out of state. That is a good news scenario that is up from previous years. That means that agencies are being very creative in order to attract folks from other states to come work in Oregon. So kudos to all of you in that space. Almost half of agencies, around 48% of all agencies, have had failed recruitments. Half of those, again, have had multiple failed recruitments. And as you know, that's a huge waste of resources to conduct a recruitment and not have a viable candidate come out of that can pass a background check or a psych eval or what have you. We've also anecdotally heard of a lot of no-shows. So agency goes through the process, hire somebody, day one, they don't show up. And that is indicative of the culture change that we see within the profession. As you also know, pre-pandemic, pre-police reform, the average retention of a law enforcement officer was somewhere between 10 and 15 years. Post-pandemic, now we align right up with a national average of 5 years. That's alarming, and there's a lot of work to be done in that space. I talked to a chief of a Tier 3 agency, which is a small agency. Tier 3 agency is 25 or less officers. That the chief said he had more years in service and experience than the rest of his officers combined. That's pretty scary. And you start to think about who are the FTOs, who are the ones training those officers out in the field, what kind of experience do they have to be able to train those new officers coming in. So there's a lot of work to do in that space, and DPSST is really doing everything we can to try and support you all, to support the profession and Oregon with trying to figure out what the problem is. How do we solve this problem? The Center for Policing Excellence, which is a unit here at DPSST, has conducted a survey called Choosing to Serve. And this survey will be released to all of you, to the public, to all our constituents in late spring. We're aggregating the data that we've received from this. And really what it is from a high level is a poll for leaders in law enforcement agencies and officers in law enforcement agencies to compare and contrast what is important to them, how the leaders view what's important to officers that will stay in their organizations, what makes them want to leave, and so forth. And what we're seeing in the early data is there's a pretty good alignment in the top 3 reasons, meaning the leaders are saying, hey, I think these are the top 3 things, and the officers are agreeing, yes, those are the top 3 things. But when we get down to the subsequent reasons below the top 3, it starts to diverge. And that divergence is really interesting and should be some really useful information for leaders of law enforcement agencies in their strategies for retention and hiring. So that's really good. And we'll look to release that in the late spring again and provide that to you. Also, and I'm really excited about this, DPSST is going to partner with multiple agencies to do a children's camp. And we really want to open this agency up and bring children into the agency, show them what the profession is about, show them what the training is about. A couple folks in the room, I've already signed on to partner with us on that. Sheriff Duncan, thank you very much. Superintendent, appreciate that. There are a ton of agencies already signing on to this, so I really appreciate the participation with that. We're looking at bringing, and this will be our first pilot, we're looking at doing this in July, during the July 4th week, which is also a down week here at the Academy, and it's a good time to do this. All these agencies will come together and figure out what activities we're going to do for the kids. It's going to be a one-day academy as our pilot. We're going to do a bunch of fun things and also educational things with the kids. We're looking at grade school kids first, and then we hope to expand that as time goes on to hit different brackets of children all the way up through high school and so forth. So we're very excited about this, very excited to partner with all of your agencies to do this and to have, a menagerie of uniforms here while we do this. I think it's going to be an excellent partnership and great opportunity. Last thing I wanted to announce for all of you, which is an invitation, and I'll send this out formally in the mail. March 17th at 0900, we will be commissioning a bench out here in the courtyard for our previous board, Jason Myers, previous board chair Jason Myers, and we have appreciated everything that he did for us, for the profession, and so we have a bench with an inscription, a plaque that will be commissioned out there in the courtyard. I want to invite you all to attend that. And again, we'll be sending out that invitation. And now, before I turn it over to the Deputy Director here, I want to open myself up for questions. If you have any of me, happy to answer those.
Director, is there a cost associated with that day camp, or is that?
No, that's going to be free for the kids.
And they can sign up online?
We haven't got there yet.
Okay.
We just literally kicked this off yesterday. That work group was going to come together and build all that out. More to follow.
Do you even have a number of how many kids you accept?
We're shooting for 100. Yeah.
Grade school?
Yes. I hear you volunteering.
You're in charge. You're in charge.
We have a lot of volunteers already, which is fantastic. So
I think it's great. I mean, I think a lot of, and we've been looking at it too, the recruiting techniques are talking about what's going on in society today, and we can't target them at 19, 20 years old. We've got to hit those lower levels, because I think that's where you're having problems with your background, is they've grown up this whole time thinking that, you know, smoking weed is okay and doing all these things are fine, and then they come to us and with an epiphany that they want to be in law enforcement, and if you can get them at a younger age to kind of stay on that right track and straight and narrow, I think it would be helpful.
One thing I learned is that when doing outreach with the schools is we weren't even in the conversation for career fair. All of a sudden we're, you know, fire and police were the leading posters. We weren't on the posters. We weren't even asked to be at some career fairs. And so we had kind of have to do our own planting of the seed early on to at least get them introduced to it.
That's a great idea.
yes, ma'am.
So as not an officer but a former classroom teacher, would I be able to volunteer on that day just to help out?
I would love to have your help.
Okay. Oh, I'd love to do that. Thank
You
you.
just have to bring your faithful companion.
She can corral them, we can't.
Great.
Yeah, I'm going to be very brief. I think you were very comprehensive. The only thing I want to just add on about the deferred cases, we're looking real positive. The devil will be in the details and the rules that are set up, and which is why the May, because it is an FTE ask. If we weren't successful in that, how much could this team take on when they have 300 in some cases, and you have potentially 157, 58. Now, not all of those are reviewable. Some of them, like all of them, have maybe a criminal thing and they're going through the process and they're sitting, but if we're successful, then I'll be reaching out to all of you to talk about, you know, we floated the idea of should an agency be sponsoring somebody to be asked, because they've matured or we've seen life changes. So a lot of it is going to be the discussions afterwards on what rules we put in place to be able to look at these and manage that process. Because some people will benefit from pausing, maturing, waiting, but there's certainly others who, you know, could benefit from at least hearing their case, knowing their outcome. So more to come when we find out the outcome of that particular bill, but thank you. And I believe Kathy had no update, so we can give you back the rest of your day.
Thank you, Mr. Chair.
It does seem like those cases should be easier as well, right? If we're talking about a issue at the academy, maybe not as comprehensive as some of these.
That was an example, Chair.
Yeah. Oh. We started us with the easy ones.
I would think it's going to include like all the ones, because you know we have them at our agencies even after the academy, all the way up until they finish the red book and all that.
So we'll just meet every week.
It's going to be the same.
I really like you guys. We should meet every week.
It's going to be the same.
Yes, come out. Okay, so I think we're on to the next meeting is, well, we don't know what the next meeting is, but there is one scheduled May 22nd at 10 a.m. and they'll probably try to sneak a couple more before then.
Do our best. We'll be reaching out again. Thank you very much.
And I do want to say thank you everyone for paying attention to the material. Everyone is, I mean, it's so much easier when everyone knows the material and everyone weighs in. I really appreciate that. Makes me have the best committee.